Hi, this is the second lecture for topic one. And in this lecture, we're going to be taking a look at judicial decision making, in particular, legalism, the different methods for interpreting the Constitution. So, in the second half of the chapter one in your Rights, Liberties, and Justice textbook, you'll be reading about the different factors that influence the way justices rule in cases. And there are two factors that your textbook focuses on. And let me put both of those up there right now so you can take a look at them. And so one of the factors that the textbook looks at is this thing called legalism. And it is the method that justices use to interpret the Constitution itself. We're going to be taking a look in this lecture at five of the six of those legal methods that guide Supreme Court justice interpretation and helps them decide in cases. An example of that is originalism, okay? And we'll get into those in more detail in a second. The other factor that influences judicial decision making is politics. And so there's legalism, that is the legal method you use to interpret the Constitution. But there's real world sort of impacts on justices when they're making decisions. And so your textbook talks about preferences, which is another way of saying the ideology of a justice, whether they are liberal or conservative. Also about what the role that they think the court should play, activist or restrained. They also look at some external factors like the role of interest groups and public opinion, etc. And so this lecture focuses on legalism, but when you take a look at the course commentary, I will be writing about realism in more detail, and of course, you'll be reading about that in your chapter as well. So before we get started in looking at legalism, let's just take a look at the court, okay? Because these are the individuals that are here cases, read briefs, and ultimately render decisions on those cases. And we spent the entire semester reading about the decisions that the Supreme Court has made over, the many, many years. So this is the Roberts Court, and in fact, you're going to be reading the most dangerous branch that gives you a behind-the-scenes look at the different justices that serve on the court, and also gives some interpretation of key cases as well. It's an exciting book. I think you'll really enjoy reading it. And so, the courts are named because after the Chief Justice. So the Chief Justice of the United States Supreme Court is John Roberts, and so we refer to this as the Roberts Court. That he has been on the court for quite some time. He was appointed by George W. Bush, and courts are named after their chief justices. So before the Roberts Court, it was the Rehnquist Court, the Burger Court, the Warren Court, etc. And so when we get a new chief justice, then a new court era will begin. The Supreme Court, they take what's known as a class photo, and they have not taken the new class photo. As many of you know, Ruth Bader Ginsburg died in October before the election, and she has been replaced by the person that's on the side there, Associate Justice Amy Coney Barrett. And I looked there, a new class photo hasn't been made yet, so that's why she's off on the side there. This table here shows you the actual people on the Roberts Court, their name, their age and date of birth, their experience, and then the president that nominated them and the date of their appointment. Now, this is listed in terms of seniority. And so the most senior member of the court, the person that has the most seniority, is the Chief Justice. And then for the associate justices, it's the justices that have been on the court the longest period of time that rank in seniority. It doesn't have to do with age. I mean, obviously, John Roberts is 65, and Stephen Breyer is 82, and Clarence Thomas is 72. But Clarence Thomas has been on the bench longer than Stephen Breyer, and so he has more seniority. And then, as you're reading in chapter 1, when you were learning about how the Supreme Court decides to hear a case, you're reading about conferences and the rule of 4, etc. And they were talking about the seniority. That in conferences, the Chief Justice always goes first, and then talks about how they would rule in that case, or whether they think that the case should be granted a writ of certiorari. And then it goes down to the to the next person with the most seniority will go next, all the way down to Amy Coney Barrett, who has the least seniority since she just joined the court. And as I understand it, the least senior member is actually gets coffee for everybody as well. And so maybe Brett Kavanaugh will be happy to now hand that job over to Associate Justice Barrett. So another thing to notice is the kind of experience that they had before they joined the court. That a stepping stone to the Supreme Court is the circuit court, and so you'll see that many of the justices served in the intermediate appellate court, which you learned about this chapter. Everybody but one, Elena Kagan. She was the Solicitor General under President Obama. And the Solicitor General is basically the top attorney for the United States. You read about the Solicitor General in this chapter as well, and the important role that the Solicitor General plays in determining whether or not the Supreme Court is going to grant a writ of certiorari. That whenever the United States is a party in the case, then the Solicitor General represents the United States. And then you can see which of the presidents appointed. Donald Trump, President Obama appointed 2 justices, and Trump has appointed 3. You notice the ages of the people that Trump appointed. They're very young. You're going to be reading about that in the Most Dangerous Branch, about this idea of getting younger and younger justices, so they'll at least in probability be on the court longer. But this is just another graph for you to take a look at that gives you a little bit more information about the Roberts Court. Okay, so let's take a look at each of the different legal methods that your textbook talks about. Here's a list of them: Originalism, Textualism, Structural Analysis, Starry Thesis or Precedent, Pragmatism, and Polling Jurisdictions. Now, in this lecture, we are going to be looking at 5 of the 6. We're not going to look at structural analysis. It's a little bit of a complex sort of method. You'll read about it, but you'll also see in the discussion that you're doing this week that nobody's going to be assigned structural analysis. Sort of assumes a lot that everybody took American government in terms of understanding separation of powers, checks and balances, and federalism. But that being said, you're still responsible for at least reading about that in the textbook. So for each of these, we're going to, basically summarize what they mean. We're going to talk about the strengths and weaknesses of each of the perspectives. The goal of this lecture is to give you sort of an overview of what you're going to be reading in the textbook, and then you're going to use this lecture and the textbook to participate in the online discussion. So let's go ahead and get started. The first method we're going to look at is originalism. So what is originalism? Well, originalism is when justices use what the framers meant to achieve when they wrote the Constitution. They try to figure out what the framers intended, and then they use that to decide a case. Okay. Your textbook talks about 2 aspects of originalism. One is known as original intent. The other is known as original meaning. These are different, but they all fall under the category of originalism. With original intent, they do. If you use original intent, you're really focusing as a justice on figuring out what the framers wanted to do. Like, and by the framers, we mean the people who attended the Constitutional Convention as an originalist. So as, Franklin and Madison and others were sitting around at the Constitutional Convention trying to work out what's going to be in the 7 articles, and then James Madison, and then as he writes the Bill of Rights, Somebody who's interested in original intent would try to get in the minds of the framers and figure out what they hope to achieve with the words that they used to write the Constitution. Original meaning is also originalism, but it's a little bit different. Original meaning is looking at what the clauses or the words in the Constitution and the Bill of Rights, what it meant to those who enacted them. And so, not just the framers, but that when you look at the words in the 18th century context, what did these words mean to the people living at that time period? Okay. And your textbook talks about that those who subscribed to originalism, that they, will examine the writings of the framers, their letters to each other. They would look at the proceedings of the Constitutional Convention. They would look at other writings at that time period to see how clauses and words used at that time, what they meant. And then once you figure that out, then you sort of use that to interpret the Constitution. An example of that would be so in the Fourth Amendment, it says that that a person is protected from unreasonable searches. Okay, so if you're an originalist, you would say, okay, well, if you're using original intent, you would say, well, when James Madison was writing the Fourth Amendment, what did he mean when he said that that there would be that what did he mean when he said unreasonable search? What did he think that a search meant? What constituted unreasonable? And overall, what did Madison intend to achieve by making sure that people were not subject to unreasonable searches? And then if you figured out what that was, then you would use that and interpret the Fourth Amendment accordingly, even if it's a 21st century case. Using original meaning, you could do the same thing. You could say, well, what does a search mean in the 18th century? Does it mean police officers or others actually entering into your home? Is that what is meant by a search? Or is a search of some place that isn't necessarily in your home, but a private space, even though that private space is outside of your home? Like, what did that mean? Okay, those are just some examples of that. There are a lot of benefits and drawbacks from originalism. A lot of people like to think that originalism, this method, has been around for a long period of time. It seems like it has been because it's called originalism, but it's actually a judicial theory that is relatively new. It started coming out of a group called the Federalist Society. And there was a movement within the Federalist Society and within some law schools as well to basically create this viewpoint called originalism. So it's a relatively new perspective from the 1970s and 80s, but boy, oh boy, today it's a really, you hear a lot about originalism when it comes to the courts. You can read about the strengths and weaknesses. There are many. Some say that if you can figure out what the truths are in the Constitution, then it allows for value-free decision making, right? You even heard that if you watched the confirmation hearings of the new Justice, Amy Coney Barrett. She said, it doesn't matter what I think, it matters what the Constitution means. It's not me, it's the Constitution, and I'll just apply these constitutional truths. And so it's attractive in that way because it sort of takes the subjectivity of the justice out of it. For others, there are criticisms saying, well, when you say the framers, well, which framers are you talking about? I mean, there were many people who attended the Constitutional Convention. So are some framers more important than others? There was a lot of disagreement at the Constitutional Convention. So how can you derive what the intent of the framers was? But I have up there that, one of the biggest criticisms is that is it best or just to interpret 21st century legal controversies through an 18th century lens, in particular since women weren't seen, didn't have political rights. African Americans weren't even seen as citizens, but property. Is it best to sort of use what the folks who lived at that time period, use that in order to address the problems that we have today? Textualism is another method that Supreme Court justices use. Textualism, it's basically placing emphasis on the specific words used in the Constitution and then trying to figure out what those words mean. And not necessarily what they meant in the 18th century. It's just that you would look at dictionaries and you would, like used legal dictionaries to find definitions, and then think about how those words are defined over time, right? The consistency in the way that words are defined, and then you would use that to drive your decision making. Textualism is like literalism. Like these are the words that are in the Constitution, and that we shouldn't expand what these words mean. That if it says this word, then that's what we're sticking with, right? So there's a literalism that you're going to be reading about in the textbook. And so from this perspective, you don't need to go beyond the words of the Constitution to find meaning. For example, I've got two examples up here. And the example that they use from the textbook is that in the First Amendment, it says, Congress shall make no law abridging freedom of speech. Okay. Now, the Supreme Court has never defined the First Amendment literally, that Congress shall make no law. We're going to find out that laws can be made in order to abridge, to restrict speech. But there have been some justices that you'll read about in the textbook that in their dissenting opinions, they're like, it says no law means no law, right? And not only that, they talk about how it says freedom of speech, and the literalist or the textualist will say, well, speech just means utterances that come out of your mouth. It doesn't mean, it doesn't say written word. It just says speech. So the First Amendment doesn't apply to pamphlets or artistic expressions, or using like an armband, wearing an armband to express yourself, like to be opposed to something. We're going to be reading Tinker versus Des Moines case about students who wear armbands to protest war. And so that you define it literally, and that's how you use that to decide cases. If a case came up before you where a speech act like wearing an armband was restricted, you'd say, well, it can't be restricted because armbands aren't speech. Another current example of that is the recent Neil Gorsuch, Associate Justice. He used sort of a textualist approach in a recent case called Bostock v. Clayton. In that case, this was about sex discrimination. But so the Civil Rights Act of 1964 says, in Title VII of that, says that you can't discriminate in employment on the basis of sex. Well, the question is whether or not you can discriminate against people on the basis of their sexual orientation, whether they're gay or lesbian. Bostock is a case about a man. He worked for a county in Georgia, and he was gay, and he joined a gay softball league. And when his employers found out about that, he got fired because they said that being gay was, sort of a lifestyle that was one that they didn't agree with, and therefore they fired him from his job, and then he sued. In Bostock this summer, Neil Gorsuch wrote the majority opinion, and he basically said sex discrimination is sex discrimination. Okay, and in fact, you can't know somebody's sexual orientation without knowing their sex. Okay, and so in that case, he said that we're not talking about somebody's sexual orientation, we're talking about somebody's sex, and then that's sex discrimination. Okay, so he kind of used a literalist approach to that. The benefits of this perspective are that they're value free. It takes the person out of it, at least in theory, and says just look at what the word means and then apply the meaning of the word. And that there's a precision in the decision making, right? It's sort of like, you know what? It says speech, we're sticking with that. It says no laws, we're sticking with that. So that there's a sense that there's a precision with that. As your textbook points out, there's criticisms of that position. It assumes that language is precise when in fact it's not. Language oftentimes has multiple meanings. The same word can have multiple meanings. So which word was being intended, which definition was being used in the Constitution. It also leads to like weird positions, that when using the word speech, does it really mean that it doesn't protect expressive conduct? And so again, you'll read more about that in your textbook. The next method we're looking at is Starry Thesis, and that's why there is a star there, because it's a Starry Thesis night. So in this viewpoint, justices decide a current case based on the way the court has decided a similar case in the past. Okay, so they base their current decision making on previous decisions of the court, and those previous decisions of the court are known as court precedent. Okay, and Starry Thesis is basically means in Latin, in English, that Latin phrase means let the decision stand. And so once the court makes a decision on a case, then if a similar case comes up, you look back to that decision and you just apply that decision. Here's a concrete example of that. And so right now, Roe v. Wade, decided in 1973, it's the case that basically says that prior to viability of a fetus, that a woman has, it's a private decision between her and her doctor about whether to terminate the pregnancy. Okay, and so basically it establishes a constitutional right to have an abortion prior to viability. States can't make it a crime to outlaw those kinds of abortions. And so if you were a justice that used stare decisis, you would say that if a law came to the court today that criminalized abortion after the first month, right? And we're actually seeing that through some states are passing laws that are basically making either fully criminalizing abortion or saying, you know, the first month or the first 6 weeks. After that, you can't have an abortion. And that's well before viability. I mean, a fetus doesn't become viable until at least the 20th week. And so if you use stare decisis, you would say, look, Roe v. Wade says that you have a constitutional right to have an abortion until viability. These laws basically are trying to take away that constitutional right. And so I'm going to use the past decision and apply it to today. The proponents of stare decisis say that it's predictable and stable. We know what the court has decided, and so that then that as Congress or as states are making law, they can look to previous decisions of the court, and then they can make laws that reflect those decisions, right? Oh, it's unconstitutional to have an abortion law that criminalizes abortion prior to viability. So there's some stability in that as well. It's also some stability on the court that if the previous rulings were not abided by, then people would just constantly be submitting cases to the Supreme Court for review because they're like, maybe this time I'll get lucky and they'll decide another way, right? So it would, lead to some instability. On the flip side, that, past rulings are not necessarily right or just rulings. Okay, let's look at an example. An example would be Plessy versus Ferguson. Plessy versus Ferguson is the landmark case about whether or not separate accommodations are in fact equal. Plessy versus Ferguson is about the state of Louisiana. They had a law in the books that basically said that if you're black, you have to ride in the black train car, white car only. And a black person challenged that law, basically saying that law violates the Equal Protection Clause of the 14th Amendment. The court ruled that separate is in fact equal, that if the accommodations are equal, if the train cars are the same, then separate is equal, right? Well, as we all know, that was ruled, it was an unjust ruling. Most people felt that it was, and it was overturned in Brown versus the Board of Education. And so that's an example of where stare decisis was not followed, past court precedent wasn't followed, but their ruling was that that previous case was ruled wrongheadedly. Pragmatism is another approach that your textbook looks at. Pragmatism is about focusing on a cost-benefit analysis. And a pragmatist will make a decision based on what gives the most benefit, or more importantly, the decision that results in the least amount of harm. And so from a legal perspective, a justice might say, look, there are many different ways of interpreting the Constitution. You could look at past precedent through stare decisis. You could look at originalism. Okay, you could look at the text. And so there's many ways we can interpret the Constitution. I'm going to go with the method that is going to result in the least amount of harm to our society. Okay. And so they kind of pick and choose on different ways of interpreting the Constitution and go with the interpretation that results in the least amount of harm. Here's a concrete example. Okay. A concrete example is about what constitutes a reasonable search and this thing called the exclusionary rule. And you're going to be learning about this later on in the semester. There, as you know, we mentioned before, there's different ways that you could interpret what is meant as a reasonable, or really the words are unreasonable search, right? People can't be subject to unreasonable searches. You could look at what the framers meant by an unreasonable search. You could look at what the words unreasonable and search mean, okay? Or you could also look at and consider the harmful effects of um, calling a search an unreasonable search, okay? And that would be sort of the pragmatic position. In the United States, if you're subject to a search that's not reasonable, an unreasonable search, whatever the cops find, they can't use in court, okay? And that's what's known as the exclusionary rule. If it's a bad search, then the contraband that's seized is bad and it cannot be presented in a court of law. It can't be used against you, basically. So if a cop does a bad search and they find a bunch of stuff that indicates that you are likely a drug dealer, they can't use it because they didn't use the right method for the search. Well, there's a kind of a cost to that. If the search is bad and you can't use that evidence in court, well, then a criminal could go free, right? And a lot of times searches are bad for technical reasons, right? Like maybe the warrant wasn't properly filled out, or maybe there were two warrants that came to a scene, one that was not based on probable cause, the other that was, but the warrant that wasn't based on probable cause got there first, but the other one was, had been issued based on probable cause. So you basically had two warrants, and the search would have taken place if the right warrant had showed up first. But the wrong warrant, the bad warrant, showed up first, and then you got to throw out all that evidence that was found. And so, the Supreme Court has been kind of pragmatic when it comes to their interpretation of unreasonable search and interpretation of the exclusionary rule, because they're basically saying there's a bad consequence when likely criminals go free. That would be an example of pragmatism. A criticism of it is, the benefit of it is that bad consequences are reduced, right? And bad consequences can be very costly to a society. The downside of it is that your textbook talks about is that are courts adequately able to assess the possible impact or the cost of a particular situation, right? It might seem that throwing out evidence that is likely to convict somebody is bad, but maybe the consequence is that cops do a better job getting warrants and actually following the letter of the law, right? Are courts adequately capable of assessing the possible impact or the possible cost of decisions? The last perspective we're looking at is polling jurisdictions. Polling jurisdictions is that a justice would examine the practices of other jurisdictions, other cities, states, or countries, and then based on what they would find out about what those other cities, states, and countries are doing, they would use that information to guide their decision making in the case that is before them. Here's two examples. Let's say a death penalty case is in front of the Supreme Court. Well, a justice who is guided by polling jurisdictions would take a look at other countries like us, other democracies, advanced capitalist democracies like the United States, and they would say, is the death penalty considered cruel and unusual punishment in those countries? Well, if it is, then we're like those countries, and so our laws or our interpretation of the Constitution should be in line with countries with the community of other nation states. Another example would be looking at states within the United States. This is the example that they use in the textbook, is that the Supreme Court in Mapp v. Ohio was asked whether or not the Fourth Amendment implies that the exclusionary rule, that is evidence that's improperly collected, is inadmissible in court. And they basically said, look, many states in the United States use the exclusionary rule, so therefore the exclusionary rule should become a constitutional provision, looking at the polling jurisdictions and saying, based on that, then we're going to decide this way. The benefits of this perspective are that it keeps the decision in line with the broader community practices. And so the Supreme Court's ruling should reflect what many other states are already doing. It should also maybe reflect what other countries are doing, right? But the downside of this, as your textbook points out, is that what other countries do, or even what other cities and states are doing, right, should have no bearing necessarily on how the Constitution is interpreted. And so, what other countries do, or what cities within the United States do not necessarily apply to American law and American jurisprudence writ large. Okay, so that's an overview of that perspective. Check out the handy little table that you have in your textbook that takes the 6 perspectives, and it takes the issue of how to interpret the Second Amendment, whether or not the Second Amendment gives states the right to create a militia, or whether the Second Amendment should be interpreted as a individual right to bear arms. And then it shows you how those different methods would interpret the Second Amendment. Keep this in mind as you are working on your project for the online discussion. Okay, so topic 1 discussion gives you an opportunity to apply what you've learned about legalism. So when you take a look at the discussion, there's instructions in the discussion. So this is just like an overview of that. It shouldn't substitute for you actually reading those instructions. You should obviously listen to this lecture and then read the part in the textbook on legalism. As you'll see in the discussion, everybody is assigned one method of the 5. We're not doing structural analysis. And then you take your method, whatever it is, and then you apply it to a hypothetical case about the death penalty. It's about a 16-year-old being sentenced to death by virtue of public hanging. And the case comes to the Supreme Court, and you're a justice who's supposed to rule in that case about whether or not that kind of application of the death penalty is a violation of the 8th Amendment. So you use your method to explain how you would rule in the case. It asks you what materials would you examine to guide your decision making. So like if you're given originalism, what would you look at to figure out like how you're going to rule in that case? And then it's saying based on what you find in your examination of the materials that you would use to help you determine how to rule in that case, then it asks you how you would theoretically rule in that case. Keep in mind it's described in the instructions that I'm not actually asking you to go and do research at the library about the founders, how the framers, and what they meant when they said the word cruel and unusual. I'm just asking you to theoretically, what would you look at, and then based on what you like theoretically would find, then how would you rule? Okay, and that makes more sense when you take a look at the discussion. All right, cool. I look forward to reading your posts, and thanks for sticking this out. It was a little bit longer than usual, but it takes a little bit long to get through those 6 methods. All right, talk to you again soon. Bye.